All right. Calling Regina versus Bick.
Your Honor, Jess Patterson appearing on behalf of the Crown. Last name spelled Patterson.
And Your Honor, Chris Massey appear as counsel for Mr. Bick. He's the gentleman who's before you. We'll be seeking his release today on judicial interim release.
All right.
Yes, Your Honor. As my friend indicated, this is Mr. Bick's application for judicial interim release. The Crown is opposed to his release on the secondary ground. Your Honor, I'll start off by adducing Mr. Bick's criminal record.
Yes, that's acknowledged, Your Honor.
Okay.
Mr. Honor, there are two offenses before the court today. A break and enter into a dwelling house from the 10th of January and a possession of stolen property from the 16th of January of this year. The circumstances of those offenses are as follows. On the 10th of January, Miss Marjorie Lowland returned to her home at 1201 East Thurlow Avenue in Victoria at approximately 4 o'clock in the afternoon to discover that her home was somewhat in disarray and that there were some things missing. And initially she just noticed that there was some cash missing from the dining room table. She called the police. They attended. They found that there was a broken window to one of the basement bedrooms and a sliding aluminum window. There was glass missing over an area of approximately 6 to 8 inches, and through that opening, the latch could be opened. As part of their investigation, the police also noticed some finger marks on another basement bedroom window in the house, and they were smeared sideways in a manner which was consistent with someone trying to open that window. The police took fingerprint impressions from the outside of that window and ultimately located a fingerprint which matched that of Mr. Bick. With this information in hand, the police attended at Mr. Bick's residence on the 16th of January and executed a search warrant. They went in, recovered a number of things, including a small box, a quantity of gold chains, and a used glass crack pipe. Ms. Lowland identified the gold chains and the box as being ones that were hers and had been taken on the 10th of January. Those are the circumstances with respect to the allegations before the court. I'll just take your honor to Mr. Bick's record at this point. You'll no doubt note that Mr. Bick has 5 prior convictions for break and enter. And in fact, had just recently been released from his last custodial sentence for break and enter prior to this offense. He also, in the course of his criminal history, has a history of violence, including 2 convictions for robbery and a sex assault conviction from 2015. Of particular note, Your Honor, I'll take you to the 2005 conviction for manslaughter. Mr. Bick received a 7-year sentence with respect to that offense, and what's particularly noteworthy is that that manslaughter occurred in the context of a residential break and enter, where the homeowner arrived home to interrupt Mr. Bick in their residence, and he killed the homeowner as part of his escape from the residence. Of course, as I indicated at the outset, the Crown's seeking to have Mr. Bick detained on the secondary ground, and these offenses are of particular relevance when you consider the test on the secondary ground, and the Crown says that that's met here, that Mr. Bick's detention is necessary to protect the public, having regard to all the circumstances, and that given Mr. Bick's track record of committing crimes of violence and property crimes, and specifically break and enters. The Crown says his detention is necessary because there's a substantial likelihood that Mr. Bick will reoffend should he be released. Subject to any questions Your Honor might have, those are the Crown submissions.
No, thank you.
Thank you, Your Honor. If I could just have a moment to confer with my friend.
Certainly.
Thank you, Your Honor. I will begin by letting you know that what I'm proposing today is that Mr. Bick be released on surety bail to attend a residential treatment program. And his son, Richard, is present in the gallery today, and he is prepared to stand surety for his father. I'll explain more about the release plan in a moment. But I wish to address two things before I do that. The first is to speak first about the strength, the putative strength of the Crown's case, as it's been disclosed to us in the particulars. And secondly, to tell you more about my client's background and recent issues that he has had with drug addiction and attempts at treatment and recovery to date. And then turn to discuss the release plan that I mentioned a moment ago. Dealing first with the issue of the strength of the Crown's case, Your Honor, in my submissions there are significant weaknesses apparent in the Crown's case on its face, and that is a factor I'm asking Your Honor to consider today in terms of whether Mr. Bick ought to be entitled to judicial interim release. According to the report to Crown Counsel, on January 16th, officers attended to Mr. Bick's residence after learning that a fingerprint found at the scene of the break and enter had come back as an alleged match to Mr. Bick. There's certain things to note here. First, this is some 6 days after the break and enter has occurred. The officers at this time had no warrant for Mr. Bick and no warrant for his residence. Whether or not they had grounds to arrest him, they certainly had no Feeney warrant. There was no suggestion of this being hot pursuit. Again, this is 6 days after the fact. And there were no exigent circumstances that would have justified entry into the residence because of any danger to anyone inside. The officers simply knock on the door and upon getting no response, decide to enter his residence uninvited, whereupon they found Mr. Bick sleeping in his trailer. Mr. Bick was then placed under release and certain items were found in the trailer. Now, my friend advises that this trailer was searched pursuant to a warrant, but what's important to note is that that warrant was sought and obtained after the unlawful entry into Mr. Bick's residence. I'm sure Your Honor will recall the circumstances of the Feeney case where the Supreme Court of Canada held that evidence, even in a murder case, could be excluded in the event of a breach of an accused Section 8 rights in these circumstances. And that was at a time when the law was uncertain. It's now been some 23 years for the police to digest the significance of R versus Feeney, and in my submission it is highly likely that any evidence found in Mr. Bick's trailer in this case will be excluded at his trial because of the egregious breach of his Section 8 rights. I also note that the only items that were found in the trailer that were allegedly taken from the B&E and in any way directly connected to the residence in question were not in fact reported stolen by the complainant until after they had been seized by the police and shown to her, at which point she alleged that they had in fact also been stolen in addition to the cash which she originally reported missing. The Crown's case then, in my submission, is likely at trial going to boil down to nothing more than a single fingerprint found on an exterior window of the residence. And it's worth noting, Your Honor, that that window is not in fact the point of entry. The point of entry is a broken window to a different bedroom of this residence. The report to Crown Counsel is clear that the fingerprint allegedly identified as Mr. Bick's was on a window to a different bedroom. And I'm sure Your Honor will be well aware, fingerprints cannot be dated. There will be no evidence at trial as to when that print was left. It could have been there for years. In my submission, there is good reason to believe that the Crown's case is essentially once charter issues are taken into account, a circumstantial one where conviction is by no means a certainty. In other words, Your Honor, there are serious triable issues in this case. And all persons are entitled to the presumption of innocence and to a presumption in favor of judicial interim release for that very reason. And in my submission, that presumption is even more important where the Crown's path to conviction is this uncertain. Your Honor, I'd like to turn now to speak more about Mr. Bick's background and his personal circumstances. He is 59 years of age. He was raised in Calgary by a single mother, and he describes to me having a series of stepfathers, each of whom was more violent and more abusive than the one before. At the age of 16, he tells me he left home, essentially to escape the abuse, and wound up living on the streets. He quickly made his way out to Victoria, where he lived and where he has lived ever since. His education ended at approximately grade 10, and as you can imagine, as a vulnerable young man with few resources living on the streets of Victoria, he fell into a crowd where drug addiction and drug use was common, and it wasn't long before he himself developed a drug addiction. He tells me at the age of 17 he was introduced to heroin for the first time, and he quickly developed an opiate dependency. That addiction, combined with his poverty, led to the entries that you'll see on his record in the 1980s when he was in his 20s. They are largely property offenses, and they are motivated by his addiction. However, you'll notice, Your Honor, that after the conviction in 1991 for obstruction, Mr. Bick's record suddenly goes quiet. There is a 14-year gap in his criminal record, which in my submission is quite remarkable given the trajectory that he appeared to be on at that point. My client tells me that the reason for that decade and a half during which he had no involvement with the criminal justice system was that he had managed to get himself clean. He attended a residential treatment program in 1991 following his release from custody, and was able to keep himself clean from hard drugs for the next 14 years. During that time, he went back to school and he achieved his GED. He began working at restaurants and was eventually able to put himself through culinary school, eventually earning his Red Seal. In 1995, Mr. Bick got married, and within the next 3 years, Mr. Bick and his wife would have 2 children, Bo Bick Jr. and Richard, who's here today. They were able to purchase a home in the Fernwood area, and in 1997, Mr. Bick opened his own restaurant called the Weasel Cafe, which would go on to earn a Michelin star rating, and eventually a visit from the Queen during her royal visit to the province in 2002. And in fact, I'll pass up to Your Honor a photograph of Mr. Bick with the Queen in 2002 during her royal visit. Your Honor, despite his troubled childhood and early struggles with addiction, Mr. Bick achieved a remarkable level of success throughout the late 90s and early 2000s. By all accounts, his family were happy, contributing members of society, and he was doing extremely well. Sadly, that entire life that Mr. Bick had built up for himself came crashing down around him on one fateful night in 2005. Now, my friend has provided me some late disclosure today concerning the circumstances of that conviction in 2005, but I'm happy to report that my client has some additional features or circumstances to add about the manslaughter conviction. It was a night on which Mr. Bick had been working late at his restaurant. It was after closing and his serving staff had left. Mr. Bick decided to stay behind with one of the staff members who was a good friend of his, and they began drinking in the restaurant after hours. They drank perhaps more than they ought to have, and eventually decided to call it quits and head home. Mr. Bick wasn't driving, he was simply walking as he lived not far from his own restaurant. However, in the dark, in his state of intoxication, Mr. Bick stumbled past his own residence and inadvertently entered the residence of a neighbor whose door was unopened, this being Fernwood several decades ago. Mr. Bick thought he was in his own residence and in his intoxicated state crawled into bed with his neighbor's wife, unfortunately. It was those circumstances which the Crown alleges were a break and enter, but in my submission were a case of innocent intoxicated mistake that led to the confrontation between Mr. Bick and his neighbor, whereupon Mr. Bick grabbed a lamp, thinking he was defending his own wife, struck the neighbor in the head, and the neighbor regrettably succumbed to his injuries. The conviction that followed and the 7-year jail sentence that was imposed took a devastating toll on Mr. Bick's life. He lost his restaurant. His family was forced to sell their home to support themselves in his absence, and Mr. Bick's wife eventually left him for her Pilates instructor. Despondent, Mr. Bick, still incarcerated, returned to old habits. He tells me that during his incarceration, he began using the drugs that were smuggled into the institution, and he became addicted to opiates once again. He would eventually be paroled in 2009, but life looked much different now for Mr. Bick. His family had disintegrated, his business was lost, and his addiction was no longer under control. And it was in those circumstances that he found himself back before the courts for what are largely property-related offenses again over the past 10 years. Again, a gentleman with limited income and addiction that he's financing and struggling to put his life back in order. He has done the best he can over the last 10 years to keep himself employed working as a cook at various restaurants throughout the city, but he would be the first to acknowledge that he hasn't yet been able to achieve the level of sobriety that he found in the 1990s. But that brings me to the release plan, Your Honor. Mr. Bick has been in custody now since his arrest in this matter on January 16th, so he has almost a month now of clean time and time to think, time to plan, and time to discuss with his family his next steps forward. And during that time, Mr. Bick has been in regular contact with his adult son, Richard. Richard, or Dick as he's known, owns and operates a painting company here in Victoria. And Dick and his wife own their own home in Langford, where they live with their 2-year-old daughter. And my client and his son has spent the last month actively looking for a residential treatment program that would be suitable for Mr. Bick's needs. And I'm happy to report that Mr. Bick now has a bed waiting for him at a residential treatment program in Surrey called the Hail Mary Recovery House. And I'm going to pass up to Your Honor a letter from Hail Mary, which I've provided my friend a copy of. Pretend that's a copy.
Thank you.
And Your Honor, you'll see that the letter confirms not only that they have a spot for Mr. Bick as of today's date, but also provides some particulars about the program. You'll see that Mr. Bick would be expected to stay for a minimum of 90 days and can stay up to a year at the residence. He would be expected to be in the residence every night from 9 p.m. There is an institutional curfew of 9 p.m., although of course it would be up to Your Honor if you wish to impose more stringent conditions. I've spoken with the society and they advise me they can accommodate those. Hail Mary has staff on site 24 hours a day, and they are committed to maintaining regular contact with Mr. Bick's bail supervisor and commit to reporting any breaches of either their policies or any bail conditions that Your Honor should choose to impose. The letter also sets out some of the components of the program, which include daily group therapy sessions, one-on-one counseling focused on cognitive behavioral therapy, and daily guided mindfulness sessions. Also, residents at Hail Mary have the opportunity to help with the center's rodent rescue center, where the center, I understand, rescues injured rodents such as raccoons, squirrels, and other vermin. The residents assist in nursing these rodents back to health, walking them around the complex every day, and each resident is given the opportunity to adopt a support rodent to be their companion through the recovery process. It is, as I understand, a cutting-edge program with a very high rate of success. Mr. Bick's son, Dick, is prepared to act as surety for his father during his release, and he tells me he is prepared to drive his father directly to Hail Mary as soon as he is released. He intends to be in regular contact with the coordinators of the program and will not tolerate any breaches of the order. He wants his father to get treatment because he remembers the man that his father once was before his addiction resurfaced, and he is confident that with appropriate treatment, his father can once again overcome his addiction and find success again. I'm going to pass up to Your Honor a letter from Mr. Bick's son. Provide a copy to my friend.
This is his son, Dick Bick?
That's
Is
correct.
it?
And you'll see that Mr. Bick's son expresses support for his father, understands his responsibilities as a surety, and again, he's committed to rendering his father should he leave the treatment program or breach his conditions in any way. The last letter of support that I will pass up, Your Honor, is another one that I've received just this morning. It is from Her Majesty the Queen. I'll pass up this letter. Again, I have a copy for my friend.
Oh, yes, Betty, yes, I see that.
You see that Her Majesty comments on how delicious Mr. Bick's crumpets were during her visit in 2002 and expresses her sincere desire that he be given a chance to find redemption through treatment. So I'm asking you, Honor, to consider releasing Mr. Bick on a release order with conditions with one surety. Those conditions can include that he travel directly to the Hail Mary Recovery Society house in the immediate company of his surety, that he not leave the recovery house without the prior permission of his bail supervisor, and that he obey all rules and regulations of the program, that he abstain from the consumption of alcohol and drugs, and of course any other conditions that Your Honor considers appropriate to secure his good behavior upon release. In my submission, Your Honor, Mr. Bick is not an individual who is permanently ensconced in the life of criminal activity. 14 years he contributed to our society and to our community in a meaningful way. It is the drug addiction issue that has caused him to fall back into crime and back before this courts. There are good reasons to think that Mr. Bick, that the case against Mr. Bick will founder at trial. He's entitled to a presumption of release here, and in my submission, his road to recovery can start today. And his vote between the combination of his son as surety and the treatment program that's being proposed, there's good reason to think that these conditions can provide an adequate level of control within the community such that he can be released prior to trial. Those are my submissions, Your Honor.
Mr. Massey, what is your client's plan after he gets released, should he complete successfully the treatment program and finds himself released into the community with his support squirrel? What are his plans for residence? Where is he going to live, and what do you propose for control on his behavior during that period of time prior to trial?
Your Honor, you'll see in the letter from Hail Mary that residents can stay at the society from anywhere between 90 days to up to a year. I understand from speaking with my client, he would like to stay as long as possible. He knows that his recovery will not be a brief one. I am proposing that one of the conditions of his release be that he not leave the society without permission of his bail supervisor. So if at some point along the way, whether we're 3 months in, 6 months in, 9 months in, he concludes he feels he's had enough time at the treatment center, he would need to persuade his bail supervisor that that is appropriate before he would be permitted to leave. At that time, whenever that is, if it's 6 months in or even 12 months in at the end of his stint at the society, I've spoken with his son, and his son Dick is prepared to have him live at the family home with him. So he would, in all likelihood, be residing directly with his son. But again, that would be up to the bail supervisor to approve in advance, and he would have to satisfy her that the arrangements made with his son are appropriate.
Okay. Mr. Patterson, do you have anything to say about Mr. Massey's submissions or plan, and in particular, do you have any comments on his suggestion that the Crown's case is fraught with difficulty, and by detaining him, I may be imprisoning somebody who's eventually acquitted of all the charges?
Yes, Your Honor. I'll address the first issue, the strength of the Crown case. And at this point, Your Honor, I would say the Crown's case is strong. As is always the case, there are tribal issues here, but those are issues that will best be sorted out at trial and not be dealt with today as part of this bail hearing. With respect to the release plan, Your Honor, obviously I appreciate the creative release plan that my friend has come up with. And it addresses some of the Crown's concerns, but, and I understand Mr. Bick's issues with addiction, but what hasn't been explained is the history of violence, and specifically what's of concern for the Crown is the recent sex assault conviction from 2015, which causes the Crown a great amount of concern, especially considering his earlier convictions for violence, including the manslaughter conviction. So the Crown says that despite my friend's creative release plan suggestion, that Mr. Bick's detention is still necessary in order to protect the public.
All right, thank you.